What happens if my loved one passes away and has a mortgage on their house? Hey there, my name is Ron Payne. I'm the CEO and managing partner here at Payne Law in Kernersville, North Carolina, where we help families navigate life's important decisions. If you've lost a loved one, I'm really sorry to hear that, and I know how stressful it is. And I just want you to know that federal law protects a house when a loved one passes away. So what I mean by that is you've got several options for how to take care of things, but what you need to know is the house mortgage just needs to be paid. So sometimes there's going to be debts where we tell you don't pay that. Like, for example, if there's credit card debt, don't pay that. It might have to be paid, it might not have to be paid, but unless your name is on the debt, it is not the family's responsibility to pay the debts of the loved one. There might be reasons you need to, there might be reasons that you'll be required to, but you need to first open the estate, see what assets are in the estate, because if you front expenses for the estate and then there's no money to reimburse them, you're not going to get that. The reason that a house is different is because houses are paid with mortgages. Mortgages are secured, and what that means is there's a deed of trust on the house that says if you don't pay your mortgage, you can be foreclosed on. Now here's the catch. Don't let a bank tell you you've got to refinance, especially with the way interest rates have gone up over the last couple of years. Sometimes an unscrupulous loan officer is going to tell you, oh, you have to refinance because if they're gone and you're not on the mortgage, then you can't do anything with it. Not true. So federal law prohibits a bank from requiring you to refinance a mortgage unless certain things take place. So if somebody passes away and you are the next of kin, so you inherit the house, whether you inherit it via intestacy, whether you inherit it via a will. Intestacy just means I don't have a will, there was no will. And of course, if you inherit it via will, or if your name was on the deed, so you owned it with your husband and wife, you do not have to refinance. You do have to make sure the mortgage gets paid. That's the difference. As long as the mortgage gets paid every month, they can't force you to refinance. They can't force you to do anything. If the house is already behind on payments, maybe you didn't realize this, you're just now watching this video, and the house hasn't been paid for 3 months, you can call, and the heirs or the beneficiary, whoever's inheriting the house, or whoever's going to remain the owner of the house, is entitled to the same protections, foreclosure knowledge, training, workarounds that anybody else would have been entitled to had they been the original borrower. So you have options available to you. Get that taken care of first and foremost. All of the other bills, they can wait until the notice to creditors is run, you determine if the estate has any money, and then you can go from there. So there's a couple times where you would have to pay off the mortgage. The first one is if you're going to sell the house. Makes sense. Because if you're transferring it to a non-family member, right? So you're selling the house, then that's the due on sale clause in the mortgage, which they can't invoke just for the reasons of death. But if you're selling it to you're putting it on the market and you're going to sell it so that way you can take care of the things, then those proceeds could be used to satisfy the estate, maybe not. But you do have to pay off the mortgage. The secured mortgage is going to get paid off first. So if you go to sell it, then the mortgage will get paid off then. But they can't force you to do that so long as you make the payments. And then we can go from there in terms of figuring out, is the house needed to pay the bills of the estate and that sort of thing. And until then, do not sell the house. And if you're wanting to sell the house within a couple of years of the loved one passing, or hey, I can't keep this up, we need to get it on the market, then the team at Payne Law can help you with that too. Because if you're selling a house within 2 years of a loved one's passing, you have to run notice to creditors, and the funds of the sale may be needed to help pay the debts of the estate. Of course, oftentimes the proceeds of a house will be more than the debts of the estate. You'll still end up getting the funds, but it's just a matter of making sure we follow the law. The team here at Payne Law is here to help. It's already hard enough when you're dealing with the loss of a loved one, and we can help you navigate those important decisions at the courthouse. And as a matter of fact, if it deals with the courthouse and probate, we'll take care of it for you. You can take care of your loved ones. You can worry about the arrangements and being there for each other and supporting each other in your time of need, and let us deal with the courthouse, the legalities, the creditors, bill collectors, You don't have to worry about all that. You let the team at Payne Law take care of that. We are available for free probate consultations. If you're looking to hire the team at Payne Law, we offer a free probate consultation to see how we can help and what the best form of an estate might be. Sometimes, if estates are small, we can open a very simple, non-full estate, and other times we need to open a full estate, especially if you're trying to sell a house and that kind of thing. So we look forward to speaking with you. If you'd like to talk to us, give us a call at 336-281-6928 or reach out to us on the web at applepaynelaw.com. We'd be happy to meet with you in person, via Zoom, or via the telephone, and we will make sure that you and your family are protected as you make these decisions. Until next time, I hope this has been helpful, and have a great day.